The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. It's 9:30 here, so I would like to go ahead and get started. Thank you for joining us today. My name is Erin Kopek, and I'm the Marketing Director for Higher Level, a workforce management resource. Today, you have joined our Workplace Excellence webinar entitled Preparing for the New Open Role, the Final Considerations about Policies, Procedures, and Training. So I think you guys will take some really good resources back today with you to utilize as the new law is quickly approaching. Just a couple things before we get started. The call will last, it'll be less than an hour. This morning, you are set up in listen-only mode, so if you do have any questions, feel free to type those in your question toolbar, and we will address those at the end of the presentation today. We are going to do a presentation today, and the presenter today is Jennifer Zanasco with Litler Mendelson, and she will begin momentarily. So I would like to introduce her now. Jennifer Zanasco has experience in a wide range of labor and employment matters, including litigating discrimination and retaliation claims, wage and hour collective and class actions, and unfair competitive cases before federal and state courts. She has conducted fact investigations, drafted position statements, representing witnesses during agency interviews, and represented employers during fact-finding conferences and mediations before administrative agencies, such as the Equal Employment Opportunity Commission, the Missouri Commission on the Human Rights, and the Illinois Department of Human Rights. Jennifer has handled all stages of the litigation process, including formulating defense strategies, taking and defending depositions, representing employers at mediation, negotiating and drafting settlement agreements, and many more. In addition to her litigation practice, Jennifer regularly counsels employers on human resource matters, including hiring decisions, conducting investigations, complying with federal and state employment laws, and reviewing employment handbooks and other policy manuals. Jennifer served as a law clerk for Hahn, Mary R. Russell of the Supreme Court of Missouri while at the University of Missouri School of Law. She was the managing editor of the Missouri Law Review and a member of the regional mock trial and regional moot court teams. Prior to attending law school, Jennifer was a human resource specialist at a local St. Louis company. She is certified as a profession in human resources. I would like to turn it over to Jennifer to give us her take on the new law today.
Good morning, everyone. This is, for those of you that have been with us over the last few months, this webinar today is the last of our webinars on preparing for the new overtime regulations that are set to go into effect on December 1st of this year. And I've talked to many of you offline, via email, and certainly, feel free to contact me with any questions that you have about any of the materials that we cover today. And if you have not joined us for the previous 3 webinars we have done on these topics, feel free to email me as well, and I can send you the presentations from those webinars. Here at Litler, we are very busy advising our clients and helping them out with final steps in terms of the process. Right now, a lot of employers are poised to implement reclassification decisions and move forward with more of the final steps of the process of implementing these changes, so their organizations are in compliance by the December 1st deadline. In fact, our firm just had a 90-day webinar, so 90 days out from the effective date at the beginning of this month, that kind of talks about some of these final issues. And if anybody's interested in the slides from that presentation, feel free to contact me and I can send that to you as well. So I want to get started here. I do have some of the preliminary information about the new overtime regs, which we have covered in previous webinars, but I've kept it in the presentation just for background information for everyone. But as far as today, we'll talk a little bit about what the final rule is going to look like, and I think most of you are very familiar with what the terms of the final rule will be by now. Steps to prepare for to be in compliance with the new rule, And then we're going to move into really talking about, the focus of today is really talking about timekeeping policies, practices, wage and hour policies, and training. So first of all, obviously everybody's familiar with what the standards are under the Fair Labor Standards Act in terms of minimum wage and overtime obligations of employers. And hand in hand with that is certain exemptions for employers that they can use if employees satisfy certain requirements for exemptions from the overtime requirements. So these are exemptions for executive, administrative, learn professional, creative professional, computer, and outside sales. And each of these individual exemptions has its own requirements. But essentially, when we talk about the exemption analysis, there are 3 requirements that a position needs to meet for it to be classified as exempt under the FLSA. And first is that the position or the individuals in the position are paid at least the minimum salary level, which is what we're talking about with the new overtime regulations, the increase in the minimum salary level, which has kind of brought us to where we are. The second is that the employees are paid on a salary basis, which pretty much just means that they're paid a set salary, and it's regardless of the number of hours that they work in any given work week. And the final test is the duties test, and each of these exemptions has a separate duties test. And personally, right now, I am working with a number of clients that are going through the analysis of exemptions, also with an eye towards whether the position satisfy the duties test. And that's a good process for a lot of employers to go through hand in hand with making sure you're going to be in compliance with the new salary level, is really just making sure that the employees that you have classified as exempt, that they really do satisfy the appropriate duties test and they're being appropriately classified as exempt employees. So the final rule we've talked about before, the minimum salary level is going to be increased to the $913 per week. That's up from the previous level of $455 per week. There is a provision in the new rules that provides that employers can use up to 10% of the minimum salary level can be bonuses and commissions that the employer receives. So you can use that additional amount to satisfy the minimum salary threshold. I will also tell you I've recently been counseling clients on this issue too, and this is a pretty complicated issue and one that we think is going to be watched closely by the plaintiff's wage and hour bar. You know, it's going to be tricky for employers to make sure that they're satisfying these thresholds and making sure that people are actually meeting and receiving the bonuses and commissions that will get them up to the minimum salary level. So we really recommend that if you do decide that you want to take advantage of this provision in the new overtime rules, it really does make sense to consult an outside law firm just to make sure that you're doing it right, that you have the proper steps set up in order to make sure that you're making use of this this new provision in the proper way. We really think that there are going to be plaintiffs, wage and hour lawyers that are ready to pounce on employers that do not do this properly. And if an employer does not pay the bonuses and commissions that raise the employee's salary up to the minimum salary level, then the employee, you'll lose the exemption for the employee and then owe overtime to them for the applicable period of time. So this is a difficult area even for really sophisticated employers. So we highly recommend that it's important to consult counsel if you really think that you would like to use that kind of provision. And the next slide talks a little bit about exactly how that would work. The highly compensated employee test is also going to increase. And there's also going to be a threshold of automatic salary level increases in the new rule. And again, the effective date is December 1st, as everybody knows. Some state law requires that employees receive notice if their pay is going to be decreased or if they're going to have any changes in their compensation. So it's important to consult state law and see if there's any of those kind of requirements in the states that your employees are working in to make sure that you're in compliance with those laws. So I want to kind of get us through to talking a little bit about really what's going to be the substance. We've talked about this slide during every presentation, and I think it's always helpful to go over it again because these really are a good 5-step process for getting your organization into compliance and prior to the effective date for the new rules. So first is identifying employees who need to be reclassified, developing a compensation plan for the reclassified employees, reviewing wage and hour policies and processes, which is primarily, we're going to talk about that today in a little bit more detail. Communicate the changes. We talked about communications last month during this webinar. And the final piece is to train the reclassified employees and their managers. And we're going to talk about that piece today as well. So I want to move into talking about reviewing policies and processes. So policies to be reviewed that we'll talk in detail about today: off the clock work, meal and rest breaks, travel time, use of mobile devices, also different processes, timekeeping, payroll changes, and also the idea of controlling overtime hours. Really what we're looking at is, with reclassifying employees who've previously been classified as exempt, many of them may have been classified as exempt almost their entire careers. They've never punched a time clock. They've never had to track their hours. So in their world, it has never been a problem for them to, have left the office and get on their iPhone and check their work email and respond to a few emails just to make their life easier the next day. Or, if they're traveling, that, it doesn't matter, what hours they're traveling just because they're paid on a salary basis. So these employees are really going through a shift, and really they're thinking about their working time. If they are spending time after normal working hours checking their work email and responding to work emails, that time has to be tracked and recorded in the employer's payroll system because they have to be compensated for that time as non-exempt employees. So we're going to talk a little bit more about that. So the first piece, I think, which is probably one of the biggest pieces, and I think that the timekeeping notion really kind of threads through a lot of this, because I think timekeeping also goes into the idea of policies prohibiting off-the-clock work and capturing working time of employees. In terms of processes, it's really important for employers to take a look at what their timekeeping system looks like right now, and do they need to have and to make any changes to their existing system in anticipation of transferring some employees over to the non-exempt side. For some employers, the answer to that will be easy, and it will be that they don't need to make any changes. For other employers, it may be that they need to make some significant changes. So that's something that on an organizational level, you'll have to make that analysis. There are a few best practices that we recommend in terms of timekeeping. The first thing would be talking about an electronic timekeeping system. There are a lot of really great products out there. I think a lot of employers make use of web-based systems to have employees track their time. I think that there's also systems whereby employees can track time using apps on their smartphones. So definitely those options are really helpful. I would say, and I don't want to make this statement as a blanket statement because I don't think that if I say it, it's not true, but I will say generally organizations have moved from the notion of punching a physical time clock, the one time clock that every employee has to go to and punch into every day. Certainly there are certain industries that still make use of that kind of a system, but for many folks, especially folks that are going to be reclassified from exempt to non-exempt based on the changes to the overtime regulations, most of those folks aren't going to be folks that are working in a manufacturing or that type of an environment anyway. Other timekeeping best practices are paying employees based on their time punches. Some employers implement rounding systems, but some of those rounding systems can inadvertently lead to violations of the wage and hour laws. So we recommend paying employees as to the time that they actually punch into their time clock. And I say that in quotes because I just talked about how most people don't physically punch into the time clock, but the time that they actually enter as their working time. Another aspect is that employees are required to punch in and out for meal times, and also that those meal times are times that the employees get to take uninterrupted, which means that supervisors need to be aware that it's important for them not to interrupt employees when they are punched out for meal times. I will tell you that I am personally sometimes guilty of this because my assistant will often have her lunch at her desk, and because she's great at what she does, she is very good to remind us lawyers that she's on lunch. So she'll put a little post-it on her rail that says, lunchtime. And so when I walk up to her and she's on lunch, I know I'm not bugging you. I don't need you to do this right now. I'm just going to leave this right here and we can talk about it when you're done. So training your managers and supervisors to be aware of allowing employees to take their unpaid meal breaks uninterrupted. Another good timekeeping practice is some type of a certification of working hours, either requiring employees to electronically or physically sign certifications that state that they've accurately and honestly reported their time, that they've not been instructed to work off the clock, those kind of things, and also maybe an acknowledgement that if they have been instructed to work off the clock, that they'll report that to the appropriate individuals in management. In terms of, I kind of didn't include a different slide for this, but hand in hand, I think, with timekeeping systems is also talking about payroll systems. Oftentimes your timekeeping system then feeds into what your payroll system is, and they all, obviously have to work together to get employees paid at the end of a pay period. So I do have a couple of recommendations in terms of best practices for your payroll system as well. We recommend weekly or bi-weekly payroll. I think most employers are on that type of a system. It's pretty rare, I think, to see monthly payrolls these days, but weekly or bi-weekly is better practice. Making sure that there are that you do some type of minimum wage testing, and what I mean by that is that you make sure that employees are not getting deductions taken out of their checks that would make their hourly rate fall below the minimum wage. And when I say deductions, I don't mean, I'm not talking about things for like insurance and things like that that employees have opted into. I'm speaking more about things for like mandatory uniforms. Some employers will have deductions for work boots and things like that. So I'm talking more about those type of deductions that are a little bit different. But those are also something in terms of your payroll system that's good for you to be aware of and make sure that there aren't any issues there. Another part is, we talked a little bit about use of bonuses and commissions in terms of the minimum salary threshold. And certainly if you do make use of that provision, then those employees are still going to maintain their exempt status. So the idea of bonuses and commissions in terms of their pay don't make a difference, don't have an effect on their regular rate of pay. If you have employees who are receiving bonuses and commissions who are classified as non-exempt, then for the most part, those bonuses and commissions need to be included in their regular rate of pay when their overtime compensation is being calculated. I've been involved in a lawsuit over this very issue for about 4 years now. So these issues are out there and exist and can be litigated. There are some exceptions to the general rule that bonuses and commissions need to be included in the regular rate of pay for overtime compensation. And so it's important to make sure that your system is set up correctly to do that. And if you have questions and concerns about it, it's a good idea to consult an outside attorney who has expertise in wage and hour law to help you with those issues. Next, I want to turn to talking about management of overtime. I think this is one of the big issues that has really come out of talking about the transition. Employers, I don't think are necessarily, the idea of converting an employee to an hourly pay rate, that alone is not a huge issue, but then the problem is controlling overtime expenses, and how do you, as HR professionals, payroll professionals, how do you help your organization control those expenses? So now these employees who used to be exempt, who are now non-exempt, how can you control overtime expenses for those employees? So there are a couple of things that you can do. Is you can put in a policy with regards to overtime hours, and usually there are some companies that implement policies that overtime is not allowed without prior authorization by a supervisor or a manager, and usually with the caveat unless there are unusual circumstances that require the employee to work overtime. However, the policy, if you do adopt a policy that has that type of a requirement, then the other side of it is if an employee does work unauthorized overtime, the employee still needs to be paid for that overtime. However, the employee may be subject to discipline up to and including termination, because if the employee violated the policy of not getting prior authorization for overtime. So those are considerations I think that an organization needs to think about, especially if you're moving from having a large population of exempt employees to moving to having a large population of non-exempt employees. So those are conversations that are really good to have right now, especially since there's still time for everyone to get into compliance. Next, I want to talk about different wage and hour policies. So one policy that many employers, and I know many of our clients here at Litler have, are policies prohibiting off-the-clock work. And so key components of an off-the-clock work policy would be telling employees that they're prohibited to work off the clock. Any off-the-clock work will not be tolerated. In addition to that, it's important to inform an employee of what is considered to be working time. Typically, a good definition of what is working time is any activity that you are required, requested, or permitted to perform in the interest of the company or for the company's benefit. And when you talk about these off-the-clock work policies, I think it's also helpful to have examples of what can be considered off-the-clock work. Some examples can be performing work before you've clocked in or signed in, or after you've clocked or signed out. Attending a pre-shift meeting before you have clocked or signed in, performing work while clocked or signed out during your meal periods. We talked about that a little bit. Working from home and not recording the work time. I think that this part is actually one that is of concern, especially with newly reclassified employees, because they're employees that may be used to working at home in the evenings, and obviously there was no requirement that they record at that time, but as they transition to non-exempt employees, if they are still engaging in work at home in the evenings outside of normal working hours, that time would now need to be tracked and recorded. Another example is sending or responding to work-related emails at home, not recording that work. As part of a good off-the-clock work or prohibition of off-the-clock work policy, it's also important to have reporting procedures and information about how the company will investigate to the extent that there's any violations reported to them. So I would suggest that, you know, if you do have such a policy, make sure that it does have reporting procedures so employees know who they can report to if they're instructed to work off the clock, and those issues can be addressed. You know, I can tell you that there are a lot of wage and hour class actions out there that involve off the clock work, that employees were typically required and had to work off the clock. And you know, these lawsuits are heavily litigated and can take years to resolve. So sometimes having a policy will help at the front end to avoid getting into those situations. So something that we've talked about a little bit already is the idea of mobile devices. You know, any of the reclassified employees who may be using smartphones and how they would track time that they spend using those phones for work outside of normal working hours. Other considerations are thinking about policies with respect to travel time. If the employees that are being reclassified, do they spend any time traveling for work? If they do, is there a travel time policy that's in place that sets forth when and how much they'll be paid for travel time? And if you don't have that policy, you know, is it important enough, if you have enough employees that are, who are the reclassified employees that are traveling, do you need to go ahead and implement that type of a policy? Another consideration is meal and rest break policies. You know, make sure that employees know that they're prohibited from working during meal breaks when they're clocked in or signed out. I will make a note that meal and rest breaks are not required under the Fair Labor Standards Act, but they may be required under state law. So it's important to be aware of those issues. The final thing that we want to talk about is training, and really a lot of the training goes to some of the processes and policies that we've talked about today in terms of off-the-clock work, recording their time, those kind of things. So ideas for training that can be conducted for newly reclassified employees as well as their managers, so the managers know what the requirements are as well, are the idea of tracking work hours, that it's the employee's responsibility, that for the most part, most organizations, the employee is going to be required to sign in or out 4 times a day. So they'll sign in at the beginning of the work day, they'll sign out for their meal period, they'll sign back in for their meal period, and then the end of the working day. Other training would be that off-the-clock work is strictly prohibited by the organization. Also, that any falsification of time records is prohibited. And also talking about what work is. You know, when is an employee working? And we talked about the definition that can be in an off-the-clock work policy. So making sure that the employees know what is considered working time and what time they need to make sure to record on their timesheets. So lastly, I just want to, we've talked about some of the tools that Litler has that can help employers with these transitions. The first is our Navigator OT app. I have gone through training on this application, and it's it's really great. Essentially, you answer a series of questions about a certain position, and then it will give you a preliminary analysis whether the position should be classified as exempt or non-exempt. It's a pretty great way to work through a lot of different positions at the same time. Also, I've done some work with our clients on that have purchased our Litler exempt toolkit, and this toolkit I think is fantastic and money well spent for employers who are going through the reclassification process right now and going through the analysis of, you know, whether to reclassify employees and then really how the final implementation of all of that works. The tools that are in that toolkit include a reclassification work plan, a communications plan template and materials, training presentations that can be given to employees, template policies and agreements. There's also wage and hour field guides that cover wage and hour field guides, and also Litler wage and hour GPS that cover all of the different requirements of different state laws. So it's an easy way to check to make sure that you are in compliance with the laws of the states that your employees actually work in. And the toolkit, employers who purchase it also get 4 hours of expert wage and hour attorney time, and that's something I've been serving in that role for many of our clients who purchased the toolkit. So all of these resources are available for a flat fee of $4,000. So this is a really great resource. Even as an expert in the wage and hour area, I consult the toolkit. I think that it has a lot of really great resources that are put out in a way, I think, that are very easy to understand and very accessible, and I think that it's really a great resource for employers to use. So I thank you for joining us today. If anybody has any questions, I'm happy to take them now, or certainly feel free, my contact information is on the slide. Feel free to email or call me, and I can help you out with any questions that you have as well.
All right, thank you, Jennifer. Everybody feel free to let us know if you have any questions. We'll take the next couple of minutes to give you time, if you have any questions, to type those out. And again, if you was not able to attend the other sessions, feel free to reach out to her and she will give you that information. There's been some great sessions covering this material. All right, there is a question that came in. It says, you said $913 per week, but based on a 52-week year, that is less than $50,000 annual salary that I've read about. Please explain.
So compliance with the FLSA is judged typically on a weekly basis. So I do believe that if you annualize it, it is $47,476. It's possible that people have told you 50,000, or you've heard 50,000 out there just kind of as a roundup number. I think that that's kind of a number that's out there that people are using sort of as an easy dividing line. And to note too, it may be the 50,000 number may come from the DOL when they put out the proposed regulations, proposed that the new salary threshold would be $50,440. So that may be the number that you're thinking about too. But definitely the new requirement is $913 per week, which annualized is the $47,476.
All right, I do not see any other questions coming in, so I want to thank everyone for attending today and also thank Jennifer for providing us with this great information. I hope everyone has a good rest of their day.
Thank you. Have a good day.